Hello, everyone, and welcome. We will get started in just a moment. Hello, everyone. Welcome or welcome back. Hopefully, welcome back at this point in the conference. We are in the session IP Matters, Practical Ways that IP Lawyers Can Advance Social Justice. This session has been sponsored by Delegate Legal. My name is Bree Mantel. I am still the Director of Education at All Legal. I am still your Master of Ceremonies for All Legal Connect. I'm here to make sure you have a great time, make sure you learn a ton. So if you have any feedback for me or for my team, please make sure to put that in the feedback form to the right of this page, right next to the chat. Go ahead and click on that second tab to provide us with feedback. We absolutely appreciate it and definitely want to hear it. All right, just a quick reminder while the code of conduct is up here, don't be a jerk, please. I don't want to have to ask you to leave. I like you all. I don't want to kick you out of my conference and not give you a refund or anything. So please, I don't anticipate there will be any problems. There are never any problems because you guys are wonderful and amazing. But let's make sure to comply with the code of conduct. We will be offering CLE credit for this session through the state of California. And specifically, this session qualifies for elimination of bias credit in different states. That's categorized as different things, and different states don't require it at all. But just so you know, in order to qualify for CLE credit, I need you to be in the session the whole time. It's for live attendance only. So if you're watching this via recording, you're going to learn a lot. You're going to make a huge difference in the world and in the legal industry and all the things. But unfortunately, I can't provide you with CLE credit or give you a certificate of attendance if you're not live. All right, please do make sure to take note of the CLE code when I provide it. Write it down and put it in the survey that we will put in the chat. If you don't get the survey in the chat, that's okay. I'm going to send that to you at the end of the evening. So don't worry about it too awful much. All right, the next thing should go without saying, but Legal is a tech company. We're not a law firm. And so we're not going to give you any legal advice. And the views of the presenters are just those. They are the views of the presenters. They're not necessarily those of All Legal. So please use the chat to talk amongst yourselves. If you have any questions for the panel, please start those with the word question just to help us distinguish those from talking with one another. We will make sure that the panel gets to them. All right, so I'm pleased to welcome our panelist. Christian Williams is an Ivy League educated, as in both Harvard and Yale people, attorney and the founder of Bevel Law. She helps entrepreneurs and nonprofit organizations secure trademarks and protect their brands. Kimra Major-Morris is the founder of Major-Morris Law, where she works in IP, entertainment, and business law. Prior to law school, Kimra worked in the entertainment industry, including for or with CNN, HBO, BET, and all sorts of other initialisms, I'm sure. Kimra has also represented the families of Trayvon Martin and George Floyd in trying to secure IP protection for them. Finally, Tyra Hughley Smith is the founder of Hughley Smith Law, where she focuses on IP, contracts, and business law. In addition to running her own firm, Tyra also publishes The Traveling Esquire, which is a travel and foodie website. Be careful going there. It looks so delicious. And you can also check out her amazing list of countries that she's visited. That's at thetravelingesquire.com. All right, here is our panel.
So thank you so much, everyone, for being here today. Good morning, good afternoon, good evening, depending on which part of the world you are tuning in from. We are very excited to talk to you today about IP Matters, practical ways that IP lawyers can advance social justice. You have already gotten a disclaimer from Bree that this is not legal advice on the part of Alt Legal, but we are also giving a disclaimer this is not legal advice on behalf of ourselves or our law firms. This is purely informational, though we certainly hope this will be helpful information for you. And thank you once again to Bree for introducing us. To give a roadmap of where we are headed today, we will be talking about the intersection between race and intellectual property law, specifically focusing primarily on the African-American experience. So we will start with a historical context. We will then dive into the current state of affairs with the present day. We will move on to some things that you've probably seen in the news and more specific case studies. And then we will end with a panel-style discussion, probably the most important part of what you can do to advance racial justice in your everyday practice as a solo practitioner or as a small firm attorney. Now, because we're pretty much all lawyers here, of course, we need to start with some definitions to make sure we're all on the same page. These are by no means fully encompassing definitions. There's many definitions of what social justice is, but these are the ones we will be using for purposes of our presentation today. So, social justice, the idea that all people should have equal access to wealth, health, well-being, justice, privileges, and opportunity, regardless of their legal, political, economic, or other circumstances. Now, when we talk about social justice, there are two competing visions of what that might mean or what that might look like. So the first idea is that of equality. And equality is where each individual or group of people is given the same resources or opportunities. So in contrast to equality, we have equity. And equity is a situation that recognizes that different groups may have different circumstances and allocates the resources and opportunities needed to reach an equal outcome. A picture is worth 1,000 words. I wish I could take credit for finding this graphic, but I didn't. Shout out to Bree, who introduced me to this graphic. And I think it does such a great job of illustrating the different concepts we're talking about here. So in this first slide, we have reality. So we can see that there's people have a different amount of opportunity and resources. Next, we have equality. And with equality, everyone has the same resources, but we can see that the man with the taller stature is easily able to see the baseball game, while the man with the shorter stature still is not able to see the game. With equity, everyone has the resources that they need to see the baseball game. And then finally, with justice, we see that the barrier has been completely removed and everyone is able to see the game without any barrier or hindrance. So I think this graphic does such a great job of illustrating the different concepts that we have here. Now, today we're talking not just about social justice in general, but racial justice specifically. So racial justice, meaning the systemic fair treatment of people of all races, resulting in equitable opportunities and outcomes. Importantly, it's not just the absence of discrimination, but it's a proactive approach. Now, you might say, wait a minute, Christian. I have been doing my racial justice reading, especially over the past 2 years, and I've learned that race is just a social construct. So why are we using this term of racial justice? And you would be right. Race is a concept that developed during the 15th century as Europeans began to expand and to colonize other countries. And that's when we got the concept of race and the idea of being able to divide people based on phenotype or based on physical characteristics. And so if race is a social construct, then again, why are we using this terminology then of racial justice? Should we be using a different term? And my take on that is that we talk about racial justice because social constructs have societal consequences. So social construct though it may be, there are still repercussions and effects in everyday society. Now, with that introduction and those definitions, we are going to fly through a historical context of the intersection between race and IP. So a document that we are all familiar with, and a section that IP lawyers especially will be familiar with, Article 1, Section 8 of the United States Constitution. This forms the basis of patent law and copyright law in this country. And what I want you to focus in on is that this provides a benefit to authors and inventors, which begs the question historically of who counts as an author and inventor. Pre-Civil War, the answer to that question is that enslaved Africans are not authors and inventors because they are not citizens of the United States. And this actually presented a problem for slave owners because enslaved Africans were working in the agricultural industry and were coming up with new inventions to make agriculture more efficient and more effective. And slave owners wanted to be able to patent the inventions of their slaves and take credit for it. This issue came to a head June 10th, 1858, when the U.S. Attorney General handed down an opinion definitively saying, no, slave owners cannot patent the inventions of their slaves. Now, this was not because the Attorney General was an early proponent of racial justice. It was because the Attorney General concluded enslaved Africans are not citizens, therefore they cannot take the patent oath. Meanwhile, slave owners cannot honestly claim to be the inventor. Therefore, inventions of enslaved Africans are simply unpatentable. Now, historical evidence points to the fact that slave owners went on and patented those inventions anyway and took credit for those inventions. But this was still a problem, and it was so much of a problem that when the Confederacy was formed, a law was passed to deal with this issue. So here we have the Patent Act of the Confederacy, and in this highlighted section, you can see that the Confederacy specifically allowed slave owners to patent the inventions of their slaves. So while we don't have a full view of the scope of Black invention during this time, what we do know is that there was sufficient invention activity that slave owners felt the need to pass a law to take credit for the inventions of slaves. Now, not all African Americans during this period were enslaved, and free Blacks were able to apply for and obtain patents. So the first known Black patentee is a man named Thomas Jennings. In 1821, he secured a patent for dry scouring of clothing. Notice this is 1821. So this is well before the Dred Scott decision in 1857, which ruled that African Americans were not citizens at all. So this is well before Dred Scott. Now, just because free Blacks in this period could secure patents didn't mean they didn't face discrimination. Infamously, one early Black patentee had the word colored added to his application by the Patent Office, which was not standard practice. And so free Blacks, while they could secure patents, faced discrimination. And in fact, many of those early Black patents were lost in the Patent Office fire of 1836. So for patents, the big idea I'd like to leave you with historically is that free Black inventors faced discrimination from the Patent Office, while enslaved Black inventors were unable to prevent slave owners from patenting their inventions. Moving on to copyright, and I'll be specifically focusing on music, which can be a contentious area of copyright law. And so African Americans pioneered many of the major genres of American music: ragtime, blues, jazz, and rock and roll. But many of these artists died not only penniless, but also divested of their copyrights. So our first gentleman here is Scott Joplin. He was the king of ragtime, known as the king of ragtime. The sheet music for his song Maple Leaf Rag sold about 500,000 copies, but he ultimately died penniless and was buried in an unmarked grave. Bessie Smith was known as the Empress of the Blues, and she was a big star at her time, but unfortunately she was also illiterate. She was signed to the Race Records division of Columbia Records and was given a Columbia Records employee as her manager. If there's any music lawyers out there, then you know that if you're an artist and your record label is also your manager, it's probably not going to be a good outcome for the artist. This is what happened to Bessie Smith. She was paid about $200 per recording, and her manager / Columbia Records signed all of her agreements pretty much on her behalf. And so her manager effectively signed away all of the rights she would have had to royalties. Next, we have Billie Holiday, Lady Day. Fascinating life story, really tragic life story. I'm really sad I don't have time to say more about it. The one thing I will say from an intellectual property standpoint is that Billie Holiday died without a will, which meant that her estranged and abusive husband got everything, including her royalties and the rights to her name, likeness, and image. So here we see the intersection, not just between race and IP law, but also estate law and estate planning. I'm going to skip Big Mama Thornton because I'm talking too slow according to my timer. So last but not least, with copyright, we have Little Richard. Little Richard helped to usher in the rock and roll era. His hit song, Tutti Frutti, you're probably familiar with. He ended up ultimately selling that song for only $50. For context, white artists during the time got between 2 and 3% in royalties. Little Richard got no royalties when his songs were used in movies or when his songs were covered by white artists. And that was common practice at the time for artists, for Black artists not to receive any royalties. Thankfully for Little Richard, things had changed at least a bit by the time he came along. And in the 1980s, he was able to sue his record label. So Little Richard, in contrast to many other artists, was able to get at least some measure of justice in 1984 when he brought that lawsuit. So the big idea for copyright historically is that Black artists were systematically denied the exclusive benefits of copyright ownership, and I would say specifically denied the right to royalties. Last but not least, with history, we're going to talk about trademarks. Now, in contrast to patents and copyrights, where the mechanism there is much more blatant, we see a more kind of blatant appropriation or the stealing of patents, the denial of royalties. The effect with trademarks is more subtle. It's less about the stealing of ideas, and it's more, we're more seeing the way that trademarks over time entrench and retrenched racial stereotypes. First, we have a brand that a lot of you probably saw in the news last year, Aunt Jemima. For context, historically in the South, whites refused to use the terms Mr. and Mrs. when addressing Blacks, and instead used the more casual terms aunt and uncle. And that's where we got the name Aunt Jemima. So originally on the left, we can see the stereotypical imagery. She's in a servitude position. In the middle, we can see the stereotypical language. She's borderline illiterate. And even with the most recent edition, we still see the echoes of those racial stereotypes. Next, we have Uncle Ben. Again, we have Uncle, not Mr. Ben, but Uncle Ben. He's shown as a waiter or butler with a bow tie, very docile. This was, again, a prominent stereotype of Black men at the time. In 2007, the brand tried to redo the image, and they recast Ben not as a servant butler, but instead as the chairman of the board. But ultimately, that was too little too late, and this trademark was ultimately scrapped. And then we have Cream of Wheat and their character Rastus, the trademark for Rastus. Rastus is a derogatory term for Black men that came about during the minstrel period. And just like we saw with the last two, he's in a servitude position. In the middle image, we can see he doesn't know what vitamins are. He's borderline illiterate. And this just continued the tradition of stereotyping through trademarks. Lest I leave you with the impression that stereotypes have only been perpetuated in trademark law against the Black community, that's definitely not true. So on the left, we have branding from Pillsbury. The image on the left perpetuating harmful stereotypes about Native Americans. The image in the middle, stereotypes regarding people of Chinese descent. And then on the right, we have branding from Frito-Lay. Perpetuating harmful stereotypes about Latinos. And so this character is holding a gun. He's a bandito, a bandit. He's doing something illegal. So it certainly has not only been the African-American community that has experienced stereotyping through trademarks. So to leave you with the big idea for trademarks historically perpetuated and entrenched racial stereotypes, and yet under trademark law, this racist imagery was protected as valuable company intellectual property. And with that, I'm going to turn it over to Tyra to talk about the current state of affairs.
That was great, Christian. And I hope everybody can hear me. So, as we just went through kind of the historical aspect of, intellectual property and its intersection with race, I think that we should dive in and talk about the current state in an area that we all know and love and understand, and that's the law. So just so you guys know, I drew the short straw, and I am going to be doing more of the quantitative number side of things, okay? So don't fall asleep. I know us attorneys tend to shy away from all things numbers and math, but I think it's really important to understand the context, especially with respect to our profession. So that being said, unfortunately, we occupy the profession that is the least diverse in America. Law is certainly the most, one of the most prestigious and deemed prestigious professions, in the country, but it is unfortunately the least diverse. The American Bar Association a few years ago did a number of studies and gathered some information and found out that only 5% of attorneys are Black. Additionally, 5% are Latinx and 2%, approximately 2% are Asian. These numbers have remained relatively consistent. Even though there's been a lot of emphasis on diversity in law schools and recruiting and firm recruiting, this has still been a relatively consistent number. And just for comparison, the US population is 13.4% Black. So there's a definite disparity between the population and the representation in the ranks of the attorney field. So let's talk specifically about intellectual property. So IP, as I'm sure you guys are realizing, you're seeing, both in online communities and, your networking groups, that IP is one of the fastest booming and growing areas in the legal realm. It's a fast growing, high paced practice area. Unfortunately, most of the IP representation is white male. According to the American Intellectual Property Law Association, the IP field is overwhelmingly white and male. And in fact, they estimate that less than 2% of IP attorneys are African American, about 2.5% are of Latin descent or Latinx, and about 0.5% are Native American. That contrasting with 70% of IP attorneys in law firms being male. So you can see that there is an overwhelming imbalance in the area of intellectual property in the legal realm in general, and then intellectual property specifically. But it gets even more granular than that, because unfortunately, there's just a data gap when it comes to determining minorities and minority women and Black women in IP. And that simply exists because oftentimes metrics are taken in male versus female representation in law firms, and then, white and minority. So there's not that granular level of data gathering, unfortunately, when it comes to Black male versus Black women IP attorneys, or Asian male versus Asian women IP attorneys. So because of, probably some of the societal types of constructs, minorities are referred to as a monolithic group representing diversity, including both men and women. And generally speaking, when we're looking at minority, in some respects, it might just be women across the board. It's not necessarily Black women or white women or Asian women. There's not that level of granular data collection. So there is a numbers shortage. So if 1.8% of IP attorneys are Black in general, it would stand to reason that it's a drastically smaller percentage of those are Black women. Now, what are some of the reasons behind this? And I'm sure that we can all guess, based upon our experience, based upon, having some sort of pulse on, the world, the country, the legal landscape. But certainly there are systemic societal issues that play into this. I mean, that's a foregone conclusion. It's being seen across various industries. There's also a lack of STEM and STEAM emphasis for women and minorities. And that actually plays a big role, especially when you're looking at patent attorneys or things of that nature, or, women with respect to highly technical fields. So the recent emphasis will hopefully in the future, eradicate some of these differences. But, for a very long time, probably up to the last 10, 15 years, there's been a lack of STEM emphasis for minorities and women. Also a lack of mentorship. Oftentimes it can be difficult for minority attorneys to find mentors that are at the level that they want to. There's not that many minority attorneys in general. So oftentimes there can be issues with finding quality mentorship, and there have to be, people outside of those communities that are willing to take on mentees that don't look like them. There's also, playing into it, hostile work environments and lack of support. Certainly, hostile working environments is, I think, something that affects, both minority communities and women communities, especially. There have been lots of anecdotal types of stories coming out of big law firms. And that is also plays into it, because you've got a lack of support with big law versus solo, and a lot of women, minority attorneys opening their own shop because they have not found the support that they need in big law. But what's interesting is that despite the low numbers of Black women, Black men, just Black attorneys in general in intellectual property and in the law in general, Black entrepreneurship is growing at a rapid pace. Specifically, Black women are the fastest growing subset of new entrepreneurs in the United States. They are estimating, and this is from Harvard Business Review, we've also seen similar from Forbes, that an astounding 17% of Black women are in the process of starting or running a new business. That's compared to just 10% of white women and 15% of white men. So this subset is fast growing with respect to entrepreneurship, but the legal field is not reflecting that. And I think that's really important because, there are considerations that affects when you are looking at the holistic approach and the holistic situation with Black entrepreneurship and Black attorneys. So while Black women are the fastest growing segment in entrepreneurship, their businesses are deemed less mature. And what that means is that they are often less funded, underfunded, they're lacking in resources, that would allow their businesses to progress and become more mature in nature. So it's extremely important to understand that while Black women entrepreneurs are the fastest growing subset, oftentimes there are obstacles, and this goes back to Christian's, kind of picture with equity and equality and justice. There are additional obstacles that those business owners face that, maybe other small business owners and entrepreneurs don't face. Why is this important? It's important because we know that representation matters. We know that oftentimes people feel more comfortable working with somebody that looks like them. We know that, even if it's a predominantly majority or a white firm, having those diverse voices, those diverse faces with real impact actually plays a strong role in servicing clients. And Kimra's going to get into a bit of, how that and how those voices can really impact the type of protections clients have. But it is important to know that representation in IP and IP attorneys does matter. It can help bridge the gap. I think that many of us in this field, our predominant client base is, Black women entrepreneurs, varying business sizes. And I think that's largely because of the representation factor. So these are things that matter. They're important. And when we're looking at the overall disparities with intellectual property, with making sure that people and their IP is protected, having representation is definitely something that matters. And now I'm going to turn it over to Kimra to talk about some of the current things that we've seen going on recently.
Thank you, Christian and Tyra. I enjoyed both of your presentations, and I'm really happy to be a voice on this panel. So let's just first define what cultural appropriation is, just sort of tying it all together. Christian helped us to see the historical impact of what happens when we don't have an even playing field, and when the laws are not on the side of a certain group of people with intellectual property. As we know, this ties into generational wealth. So what is cultural appropriation? It's the adopting of the expression, the traditions, the artifacts of a certain group without their consent, without their compensation, without giving credit, and without any input. Cultural appropriation. So what is the point? As IP practitioners, we are dealing with brand owners, we're dealing with artists. We have a direct hand, really, in all of those things, in the proper credit to a certain group, to ensure that the group gets properly compensated, depending on, even no matter what side you're on. We'll talk about that. We have the input, collaborations. We have a direct hand at whether we're going to collaborate with, help our clients to, or advise them to collaborate with what looks like it could be a competitor, but when the cultural origins of the brand or the content belong to another group, maybe making a recommendation or steering them in that direction. Some of the things that have been in the news recently: Michael B. Jordan filed for Class 33 for Juve. And if you are from the Caribbean or have any knowledge of Carnival, you know that this is a tradition that started in the 1800s. And Juve, the translation for that is daybreak. And it's before dawn. It's the first day of Carnival. So this is a celebration that started to celebrate freedom. So there's folklore, there's a celebration of costumes, music, food, of course. And so Michael B. Jordan, you know him as one of the lead characters in the movie Black Panther, had his attorney file a Class 33 application for wine. And the name of that wine was going to be Juve. Well, as you know, when you have a foreign word, you have to define it. And Michael B. Jordan's attorney said that this word had no meaning or significance. And so that just set off the Caribbean community, because of course it does. And so the lesson there if you look at the registrations for Juve, there were a total of 5, including Michael B. Jordan's, and the other 4 had the translation there. So, that's one way, is to look at the secondary meanings, and especially if it's right there on the trademark register. That was an easy one, and just to dig a little deeper. What is the significance of this word mark that I'm filing for my client? It has, some foreign equivalents, but you didn't even have to go that far. You could have just looked at the other definitions for that foreign word. So that's one way. TikTok creators, you may have been paying attention, the Black content creators on TikTok said that they were going on strike because the algorithm was set up in a way that if a choreographer created a dance and it took off, then the other choreographers who were not of color were getting more traffic on their pages. And so one of the examples of that happened in 2019 was Jalaiah Harmon, who created a dance called the Renegade. And so she created it, it took off, it went viral. But then some of the white counterparts on TikTok were featured on Jimmy Fallon's show and became millionaires. Meanwhile, Harmon, Jaya Thomas, she's the director of diverse representation, shout out to Jaya. But Jalaiah Harmon, the creator of this particular dance, earned some money, but she missed out on all that traffic and momentum that happened while she was being overlooked. So what could the practitioner have done? Warranties and representations, you can have that in your agreements with your clients, but more so, I think discussions are helpful. If you see that your client has taken off for something creative, just have a talk with them about where it originated. This happens a lot with our YouTubers. People just like the way some people do it better. But have that honest conversation with your clients. And if you find that they did not create the dance, that's when maybe you could recommend a collaboration or something to bring the other person in, because it's a better look, not only for your client, but for you as a practitioner, because, I'm sure it's not just attorneys wondering, well, who's that person's advisor? Who's on their team that let them do this? Because we have these conversations, but you as the representative for this person who has gone viral should give that person a nudge, especially, we're talking about the historical context. It's a very sensitive matter for people of color not to be credited with their work because of the way our IP beginnings, our IP history is reflected here with the Constitution not on our side. So that's one thing. Black Lives Matter. It's interesting to note, with all of the entries on the register, I took a look at this, and maybe someone can look at this and explain to us maybe in a later post. But Black Lives Matter was applied for, in the wake of this movement after Trayvon Martin's murder, Tamir Rice, a string of murders. This movement took off, and there are several applicants who applied for Black Lives Matter. And even the USPTO has deemed this as political. Yet, Christian Lives Matter, Fur Lives Matter for the animal lovers, Irish Lives Matter, those have all gone on to register. So, it just begs the question as to why one expression, and certainly they received a lot of momentum off of the Black Lives Matter movement because these things are post 2012, but they have gone on to be registered marks. Meanwhile, there's just been a lot of confusion, even with the Black Lives Matter mark itself, because this is another thing that I wanted to mention. As practitioners, when we have these things that are trending in the news, the temptation is, I found after working with Trayvon Martin's family and George Floyd's families, people were racing to file 846, because that was the initial report as to how long it took for him to be murdered. I Am Trayvon was also something that people were racing to file. Anything with Trayvon. If I had a son, he would not look like Trayvon, play off of what Obama's comments were. And so as practitioners, I think it's helpful to our clients if we discourage them from filing some of these things that are trendy, because they're going to be impossible to protect because they're slogans. So in some ways, the political speech that it can't be protected because everybody's holding up these signs. And so how many cease and desist notices are you going to send out? So that was one experience where I can say that collaborations certainly were helpful, because while in the beginning, not knowing how to do this, sending out cease and desist notices for people who were setting up apparel shops was not really the most strategic way to handle it, as I learned over time. What was better for my client and for the parents was to collaborate with these people who many times were supporters. So yes, they were infringing. They were making merchandise that had the mark on it, and the hoodie image that we had registered with the Copyright Office. But oftentimes, it doesn't matter what the infringer's intent is. But in some of these situations, if you're trying to drive fundraising efforts, you can issue limited licenses. And so that's another way that we can maybe support our clients who are in the midst of these, these trending stories that are so public, and we're trying to help them enforce their intellectual property rights. Another challenge and another thing that you should be aware of at trying to make a difference for your clients is the publicity rights statutes. They don't exist in every state. And so what am I talking about? In the news, we're familiar with the NCAA has now made it legal for student athletes to make money from their name, image, and likeness. And so this is really at the forefront now. But what if you live in a state that has no publicity rights statute, neither while you're alive or a post-mortem statute, meaning when you die, they look at the statute there to when people are calling you or contacting you to license a particular image, let's say for your client who's no longer with us, what are you tying the authority to protect that image to? What statute, if there's no publicity rights statute? So one thing that you might consider is copyright registrations for the family photos. Then you can license those images, because if you live in a state that has publicity rights statutes, then you can point to the statute and say to the individual or entity, you're not allowed to use this for commercial purposes. But when there is none and the person is deceased, then the images that are circulating are fair game. And so unless you quickly lock them down for the family members or for your client, any family-owned photos, then your control to be able to help your clients monetize and protect the memory of that person are going to be limited. So that's a tip there. You can also incorporate the name, image, and likeness of the person in a design mark. If you're going to do a trademark for a charitable foundation, for example, you could have the name within the logo and protect it that way if there's no publicity rights statute. But those are very important to look at as you advocate for your client. A big thing in the news also in the wake of the pandemic is that artists, entertainers have not been able to tour because of venues shutting down and for safety reasons. And so it became a hot commodity, really for them to look at selling their music catalogs. So if an artist owns thousands of songs, maybe not selling all of them, but selling some of them. But I would ask you as practitioners in this space to consider, again, how many decades, how many centuries people of color were robbed of their intellectual property rights. And so while selling a catalog might be good for some people, I would say that for communities of color, I don't think it's the best first option to have. And maybe, if you have such a client or will work with such a client, encourage them to maybe engage and offer licensing agreements for the songs instead of permanently losing that income, because that has been a problem where we have not been credited. We have not been owners of the intellectual property, just sort of passive income as people who participated on the song, but not necessarily owned it. So this is a big one also. So the practical application, I think Christian is going to guide us through some of the things we can do other than some of the things mentioned.
Yes, thank you so much, Kimra. So we are now going to transition into the discussion portion of this talk, where we're going to be talking back and forth about things that we've seen in our practices, but also looking to leave those of you who are watching with some practical things that you can do to advance racial justice in your everyday practice as a solo practitioner or as a small firm. So the first question that we are going to discuss is, how have you observed the intersection of race and IP in your own practice? And in what ways does IP law continue to entrench racial injustice?
I'll take that one. One thing I noticed is that many of my brand owners and creative clients are financially challenged. And so these legal service fees many times are out of range for them. So what I have done is I have offered payment plans. So my clients can pay installments of any amount. I don't have a penalty for that. And my way of giving back, just because there are so few of us. So we're the chosen few, right? So it's less than 2% of Black IP attorneys. So what I do as a way of giving back to my community, and others are benefiting from that, is I still do free 15-minute consultations. Why? Because there's an educational deficit. And so my free consultation covers the general questions. Do you need a trademark? Do you need a copyright? So those are the things we're talking about, and just sort of letting people know that I'm here. So we look at this as, as it used to be back in the day, you're in the village, right? So we all have to take care of the people. We have to be village keepers, right? So I've encountered this IP as it intersects with race in my practice with the clients who can barely afford the services, as well as representing victims' families in some of these social justice situations that are in the news.
I'll jump in here as well. I take a very big stance on education. I have a free Facebook group where I give out resources, talks, all of this. And I think my education background comes in. I also used to teach First Amendment law and communications law. So, I really focus, on education and as Kimra said, the information gap. And so that's one of the ways that I try to give back, also through, pro bono and low bono types of situations. But also, I really try to make it a point to mentor newer attorneys, attorneys that may be moving into the practice area, be it online and in a personal capacity, because I do see, where oftentimes, it may be a little bit more of a hesitancy to reach out, or a hesitancy to ask for help. And then, we're trying to figure it out ourselves. I actually went straight in-house after graduating from law school, and I had to teach myself everything. I wasn't able to crowdsource my legal degree or legal practice. I had to teach myself everything. So while I certainly don't advocate crowdsourcing, legal education, you guys, we need to do our own work and research. I try to mentor people as much as possible. Another way that I've kind of observed the intersection of race and IP is, and I actually have had a bone to pick with the trademark office about this, and I had a conversation with one of the directors, and that's in the idea of how trademarks are prosecuted. And we've been seeing, I think a lot of practitioners have been seeing an uptick in, I don't want to say frivolous office actions, but maybe less founded office actions that have been issued. And one of the things that I brought up to the director is that this really hurts minority and small business owners. Oftentimes clients are already trying to come up with the money for trademarks. They realize this is an important thing. And then, to get hit with a substantive 2D out of nowhere that makes no sense, is just financially burdening them even more. And it's creating more of a gap. That gap that I spoke about, Black owned businesses being less mature. The way trademarks are being prosecuted right now does not help that. And so I was very vocal about that and my thoughts on that. Hopefully some of it landed. Hopefully, we can address some of that with the trademark office tomorrow. But certainly that is one way that I've seen things, kind of go down. Also, similar to what Kimra was saying with, all these people filing things for Black Lives Matter and Trayvon, and then it's playing a game of whack-a-mole. Of course, trademark rights are only as good as your enforcement. But when, entities and Black-owned businesses and minority-owned businesses are having to play whack-a-mole with people, coming out with similar marks that they, may not have rights to, it creates an additional financial burden.
For sure. Kimra, I don't want to put you on the spot, but I think we're getting Bree with the code. So let me pause.
I was just going to come in while you were at a pausing point. So, all right, everybody, get your pen and your paper to record the code. The code is 7, equity. Note that that's different from equality. 1, justice was too long, just so you know. Again, that's 7, equity. 1. Okay.
Thanks, Bree. So, Kimra, I don't want to put you on the spot, but I just feel like you've had such a historical role as the lawyer that represented Trayvon Martin's family and George Floyd's family as they're on the intellectual property side. I just thought that people would be curious, and I know that I'm curious, just if you could talk a bit about what that was like to play that historical role.
Wow. When I first, thanks for asking. When I first got the opportunity to work for Trayvon Martin's family, I was only 3 years into my practice. So I was quite terrified, but I think it's really important to have good mentors. I happened to have joined the Black Entertainment Sports Lawyers Association when I was in law school. And I met and kept in touch with attorney Gregory Reed, and he was Rosa Parks' attorney. So I called him as soon as I was asked to manage the intellectual property portfolio. And he was the one who advised me to advise the family to start a foundation, because at first we were going to rallies and people were collecting cash and putting it in buckets, almost like a church service. And so we started the nonprofit, the Trayvon Martin Foundation. And I, along with Marlon Hill, helped to establish that, and it has really done well. I mean, so the family was able to monetize those intellectual property rights for a docuseries, and the image was in the Smithsonian. So I had the opportunity, the privilege of negotiating licenses for a lot of different deals. Artists who wanted to feature his face, or the image that we protected with the Copyright Office on their album covers. So it was really a great opportunity, but terrifying. People kept saying, that's why we call it the practice of law, because we're practicing. So that's scary. I don't know that we should really, anyway, so that you're right. So I've gotten these really unique opportunities. Right now, I am working with the beneficiaries of Little Richard. So it just seems like, I never thought that I would be in this space, but it really does all make sense. Some people are great life planners and they know how to, do things to a T. I have not been. And it just really is exciting to me and rewarding that all these things are sort of coming together to make sense, that cater to my passions and helping me to understand that, how I can make a difference, which is why this is a great panel for me to be on, because I'm not special in that way. Like, we're all licensed attorneys in this space. And so when you see something like what even just happened with the I don't know if you all saw it, but how do you say this designer's name? Balenciaga really just recently started selling saggy pants with boxers attached to them for over $1,100. And now those who've been paying attention know that Black men have been chastised for the baggy, saggy pants. There are even ordinances created. People have been locked up, suspended from school. And so now you have this Italian designer who's selling them, as well as the distressed jeans, the ripped jeans. These were because people couldn't afford jeans that weren't ripped. And now they're being sold for $1,800. So I'm just happy to be a voice in this space and to be able to share ways that other attorneys can participate in doing this community work.
I think that's a great point, Kimra, with the Balenciaga thing. And I think that, that's not the first. It's not going to be the last. I think we've all seen where, something feels misappropriated and it's the collective eye roll where it's like, oh, this new style of cornrows. And we're like, and so I think that stems from a lack of voices around people, a lack of cultural awareness, a lack of societal awareness that, seems to be running more and more rampant. But I think that that's an excellent point that, things that are, one group is being chastised for, other groups it's considered high fashion when a different group does it. And those disparities go back to, kind of all of the things that we've been talking about in this panel.
Absolutely. So we have one more question today. So I'll wrap this section by just saying that, yes, definitely, in my own practice, I've definitely observed the intersection of race and IP. And just as a recent anecdote, I was recently talking to a client. He's one of the foremost jazz pianists of our time, or I should say one of the foremost jazz pianists of our time who is still living, because there have been many in our time. But he came to me for trademark services, and he had hired an attorney many years ago to do the initial registration. And he was under the impression that enough time had passed, that it was probably time for renewal. And when I looked up the trademark, it turned out that the trademark had actually never registered. So this person's former attorney had taken their money, but had never actually registered the trademark. And so just an example of the continuing echoes that we continue to see in present day, continue to see those echoes in the past. So to wrap our session, we have the practical things that you might be able to do. There's already been so many great actually suggestions, but to wrap our session, what are some practical things that small firm and solo attorneys can do to advance racial justice in their everyday practice?
I would say that it doesn't hurt to have a team of other professionals. So, for example, publicity rights people or PR people. That's what I'm trying to say. PR people. So Balenciaga came out, just going back to that, and made a statement that was awful. They said it wasn't racist, that they had released this particular style, that all they did was put two pieces of material together and combined it to make one. So just completely tone deaf. So had they had public relations professionals, someone to help them with messaging, because it's one thing if you don't know better, but, it's hard to find a whole team of people that don't have some awareness of what not to say. So I would just say that, don't try to do it alone when you're trying to make these decisions that could really look bad for your client.
But I think it is easy to have a whole team of people who don't know better when you don't have diverse voices in the room. And I think that is a lot of the problem, why things come off tone deaf. Don't just go and hire Judy Smith, the Olivia Pope, that Olivia Pope was based on, when it hits the fan. Have those voices around you at all times, in the development stages, and have them be real voices, not just a figurehead there for, so you can say that you're diverse. and making sure that these people have a real input, a real say, and they feel like they can give these criticisms without facing backlash. And I think that that goes to the hostile work environment type of thing, where a lot of firms say, you know, oh, we're diverse, we've got, you know, diverse attorneys, but if you don't make it a caring place, a safe place for people to, you know, espouse those views, to disagree without fear of backlash, then it's going to be problematic, and it's going to end up hurting your clients. You know, certainly, Jove, somebody should have known carnival, and obviously they did, because how would you just come up with that word out of nowhere? But somebody should have been there to say, hey, you know, this might be problematic, just like some of the trademarks for aloha and, you know, the Hawaiian natives being upset about that and things of that nature. So I think taking a cultural sensitivity and really trying to look at, you know, read the room, make sure that the room has people in it that are willing to and feel comfortable espousing different views. And if you don't have that in your room, associate with other entities, you know, reach out to other attorneys, you know, HBCUs, all of those types of things, network with minority attorneys. Certainly, you know, I think that oftentimes there may be the fear like, oh, is it going to look bad if I'm reaching out to ask this question because it's like, oh, I don't know any better. I much prefer and rather appreciate somebody asking than making a huge misstep. So I think that that's really one of the keys that I've seen, and just understanding disenfranchisement has happened, and, you know, take that into consideration when you are, you know, representing your clients to try to not further that.
I just want to make one point, and I think all that is, you're right, Tyra. I don't think that people don't know better, they just don't do better a lot of times. But I also want to point out that as practitioners, we can, the emphasis, this is not about, there was a brand for us, by us. But I think that a lot of times what's happening is that Black brands are considered to be just for Black people. And so if you look at the reverse, if someone makes a product, then it's supposed to be for everyone. And, you know, take what happened with Rihanna and Fenty. She created all of these browner shades because there were no products for different complexions. And so it's not to say Fenty isn't for everyone, because she also has the whole spectrum. And so I think that also, as practitioners, we should realize that although it's great that we have Black support, our clients really need broader opportunities to be as successful as their counterparts in certain industries.
I think another thing that can be done practically, because I think that as we've started to talk about social justice, as we've started to talk about racial justice within law firms, there's too often been an emphasis on hiring that's kind of stopped there. And so the idea has been, I'm getting a little bit of feedback. I'm sorry if I'm causing an echo, but I think that there's been this idea that it really doesn't go beyond hiring. And so that's kind of been where the emphasis is. And then when we see attrition, and then when we see that not just Black associates, but people of color are leaving at rates that seem higher than other groups, then we don't really have an answer for that. And so to talk about things that we can do besides just hiring, especially since so many of us are solos, so many of us are smaller firms. And so we're only hiring but so many people, you know, every year. And so what can we do besides hiring? And I think one thing we can do is that we can give credit when we are asking associates of color, or when we are asking staff members of color, whether it's our executive assistants or paralegals or other staff members, when we're asking staff members of color to participate in non-billable things. I think that giving credit for non-billable time that is still contributing to the firm's bottom line is important. And so just anecdotally, before I was a solo, I was an associate at a big law firm. And so I was often taken to pitches for certain clients, especially clients where the general counsel was a Black person. And I'm not saying there's anything wrong with that. I think that many, if not most, law firms do that. But what that meant practically for me and for other associates of color is that at the end of the year, we ended up with a good amount of non-billable time on our time cards. And at most law firms, non-billable time translates to no bonus or other ramifications like that. And so I think that even when we have smaller firms, we might only be hiring so many people in a given year, but something practical that we can do is we can give credit to associates of color, staff members of color who are doing non-billable work, but that is still contributing to the bottom line of the firm. So yeah, I think it's time for Q&A.
Yeah, we have a few questions in here. The panel has asked me to come in and ask them. So first of all, I think there were tons and tons of comments about how people just wanted all of this all the time. So they were definitely wondering if there's a bigger course on this subject or something that you could offer. We can also discuss that later if you're not prepared to answer that right now, that's okay. But okay, so go ahead.
I was just going to say, I actually have one that should be out by the end of the year on this topic. It's a book and a workbook. So
that's amazing.
Finished. I hadn't even announced it, but since someone asked.
We have the inside scoop. That's so exciting. Please, Kimra, let me know about that as soon as you have details. Send me an email. I will get that in the newsletter because I know my audience wants to hear about that. Okay. All right. So other questions. Sanisha wanted to know about termination of copyrights, the notices of termination. She thought that would be a good project for law clinics to address the disparities in the music industry. Do any of you have any knowledge of that, or any of you working on those cases?
I do, just from working with the beneficiaries for Little Richard. For those of you who don't know, in copyright law, there's a one-time opportunity for the author of the work to recapture their rights. And so it's like after 35 years or something like that. So for a lot of the older artists who signed these agreements without knowing what they were signing, it's an amazing opportunity for them to regain their power or take their power back. But it is a one-time opportunity. And what I've found is that not everyone who's in this position has good counsel. So that's another way that we as people, representatives in this community, can help to advance social justice.
I think that's a great point, and especially in the music industry where there's been so many people taken advantage of, and artists. I mean, I've talked to some of the widows of some of the foremost, top 5 Motown acts that you would think of, and, they have nothing. So I think that this is a really important topic and things that need to be addressed, and, having counsel who can help with that is key.
Wonderful. Thank you. Shawnette wanted to know, how do you get all of the education? There was discussion about free consultations. She was wanting to know, how do you get all of that client education into 15 minutes, into that 15-minute consultation? And she wants to know if you have a script or something, or do you just go with the flow? How do you educate people in just
it's not a deep dive. It really is the basic stuff that people probably could Google, but I seem to have like a 99% conversion rate. So it's good for me to take the call. And I just say, there are 4 areas of IP. I give a one-line description of each one. And then usually while I'm doing that, they say, "Oh, thank you for saying that. This is what I need." So it's not a whole class. It really is just a few pointers because people generally don't know the difference between them. So
wonderful. And Mia wanted to know, what do you or how do you recommend educating coworkers or superiors about the importance of diversity beyond just hiring? Because obviously that was one of the things we talked about with this session, was diversity can't just be about hiring. How do you tell your coworkers, your superiors, your supervisors about that?
Well, I think Christian's point was a really good one, that making sure that non-billable time when associates are being asked to, do pitches or things of that nature is key, and making sure that that's understood. It's a tricky situation, right? Because, superiors, there's a little bit of, maybe not wanting to step out there so much, but I think that it's really just saying, look, we need to have a safe place. We need to have, think about some of these things. Let's get some different voices in a room and have an honest conversation. I think that it starts with an honest conversation. Now, there are going to be some people who are less apt and less receptive to that, but I think that trying to have an honest conversation and open that door is probably the best way to at least start the process.
That absolutely makes sense. Okay, I am afraid that we are out of time now. I think we all could listen to you all talk for basically all day. But probably your voices you couldn't talk all day. Anyway, our three panelists' contact information is here. So feel free to add them to your phones, contact them, ask them questions. So up next, in just a few minutes, we have Spring into office action, dealing with and overcoming office action refusals. We've got a few minutes as a break, so go ahead, get a drink, have a snack, take a brief bio break, and I will see you back here at 3 o'clock. Thank you so very much, panel. This was wonderful. We all loved it. And thank you all for joining us.
Thank you, Bree.
Thank you.